Our legislature needs to act to provide codification of what's known as best fit analysis. Best fit analysis is where, when an injured worker comes to court and tries to prove how much they're disabled or what the circumstances of their case are, the judge will look at certain Washington Administrative Code provisions or certain provisions of the American Medical Association's Guide to the Evaluation of Impairment Evaluation 5th edition, and there'll be standards set forth therein, but nobody's facts, usually at least, nobody's facts meet the exact standards in any one category or within any one WAC description. And so what the judges are supposed to do is they're supposed to engage in something called best fit analysis. Doctors, when they're testifying about permanent partial disability, are supposed to provide best fit analysis from a medical expert perspective. In other words, if they look at Category 1 and it contains certain elements, and they look at Category 2 of permanent partial disability, and they say, well, this injured worker has some of Category 1, some of Category 2. They're not precisely in either one of those categories, but I think the intent here is to describe a circumstance, reflecting the injured worker's severity of their condition. The best fit is Category 1 or Category 2, and then the judge can so find. The problem is this isn't codified. It's more a product of ongoing case law. But there's a few areas where the Board of Industrial Insurance Appeals is not applying this method consistently. We need it codified not only so that the board will apply the method consistently, but also so that we will end up having jury instructions that will govern and create equal justice across all different cases. And so what I need, or what I believe we need here for injured workers, is to look, for example, at the issue of complex regional pain syndrome. That's a great example of where the board's judges don't apply the law consistently with how they do in other cases. So presently, we'll prove a case, we'll take an orthopedic surgeon, the orthopedic surgeon will testify on behalf of the injured worker that they have certain elements of complex regional pain syndrome, even though not all of the Budapest criteria are met or some other listing criteria are met, including those published by the Department of Labor and Industries. But the orthopedic surgeon will testify that you don't have to have every single deficit, pseudomotor, vasomotor, nail and hair growth changes, coloration differences, skin changes in the patterns. You don't have to have every single element to have a true complex regional pain syndrome. And so right now what happens is we put on those cases and a judge will find for our injured worker, but then the Department of Labor and Industries will come over the top with a petition for review, and there's a split in the board's commissioners. So presently, one of them, the labor representative, is for ensuring that best fit analysis applies also to this and certain other conditions. And two of them, the business commissioner or representative and, kind of the third tiebreaker, they are applying the law differently for this area than will be practiced for other conditions. It creates injustices where people who have more than a regular injury can't get properly indemnified at the time of a permanent partial disability calculation, and it creates disparate results for different people. And I think anyone who's in the legislature can guess at who the incident of disparate results falls on. So we need to change it. We need to codify best fit analysis. It needs to be the law. It needs to be the law for everyone, not just a particular few.